All right, well, it's 9 after. Um, we'll go ahead and get started, and then anybody who joins, obviously, will be able to provide them either the presentation or the recording. Um, so good morning to you both. My name is Anthony Scerbo. I'm Attorney Advisor with the Office of Open Government. I'm joined here today by my colleagues, Cherie DeBerry, our other Attorney Advisor, and Nicholas Weil, our trial attorney. We represent the legal team under our Chief Counsel, Johnny Barton, and our Director of Open Government, Nikel Allen. We're also supported in our work by our paralegal specialist, Kimberly Brown. And as a group of 6, we represent the Office of Open Government, which is one of the 2 subordinate offices to the Board of Ethics and Government Accountability here in DC. I'm going to go ahead and share my screen and the PowerPoint that we will be working from. Hopefully everyone can see that without any difficulty. So we're going to talk today about the Open Meetings Act, specifically for LSATs. As an office, our primary goals are interpreting and monitoring compliance with the OMA, which is how we refer to the Open Meetings Act in shorthand. We also provide training and advice for offices of boards, commissions, and agencies on the DC Freedom of Information Act, or FOIA. We also do advocacy on governmental openness and transparency here in the district. But our primary monitoring and enforcement activity does in fact concern the OMA. These are links to various OMA references. These are short links. One is to the codification or the code, the DC official code. The next is for the codification of the regulations, which for the non-lawyers, there are both codified laws and then there are municipal regulations that relate and interact with laws. And then we've prepared a compliance checklist, which is a general OMA compliance checklist that is available. And there is specific mention made of the LSATs in it, which is available at this link. And links to all of the above are also available at our website, which is open-dc.gov. This is just a visual to give you some idea of what the Open Meetings Act checklist looks like. It's a 2-pager, not even fully 2-page, but it's a great way just to follow through and make sure that everything that you need to take into account, you're able to take into account. So the DC public policy on openness is that all persons in the district are entitled to full and complete information regarding the affairs of government and the actions of those who represent them. And that is part of that codification of the OMA that I talked about. So the Open Meetings Act generally, yes, welcome to our new attendee. We're still early on in our presentation, so you haven't missed much. The Open Meetings Act is meant to be construed broadly to maximize public access to meetings. Very narrow exceptions have been carved out, and they will permit closure of meetings only as authorized by this act. We're going to talk about where and how the OMA applies within the context of the DC government, and we're also going to talk about closure and those exceptions here in a little bit. So Open Meetings Act laws require that, with notable exceptions, most meetings of a public body will be open to the public along with their decisions and records. Decisions, we mean as the public body conducts official business, the votes by roll call that they take, and the records of those meetings, including material that gets distributed at those meetings, which we'll talk about in the context of an actual opinion that this office did for a specific LSAT. The law is designed to give the public confidence in decision-making activities of members of a public body. It's also to prevent things like conflict of interest, et cetera, along the general philosophy of sunshine being the best disinfectant. So the OMA definition of a meeting is a gathering of a quorum, and we'll talk about that because it's important, of a public body, whether formal or informal, regular, special, or emergency, at which the members consider, conduct, or advise on public business, including gathering information, taking testimony, discussing, deliberating, recommending, and voting, regardless of whether held in person, by phone, electronically, or by other means of communication. And obviously, in the post-pandemic era, all of these things occur with great regularity. The meeting is usually defined by its purpose, to conduct business, and by the fact that there's the presence of a quorum. Unless they're specifically or legally exempted, they're presumed to be open to the public. Not they're open to the public as part of a binary choice, but presumed up front to be open to the public. And the public has to receive advance notice of the specifics of the meeting: date, time, place, and the agenda as it is currently envisioned. The meeting is a gathering of the quorum, and by that we mean more than half, unless there's a statutory or regulatory definition of quorum for the public body. There are a few that have different definitions of quorum, but generally it is more than half. A meeting is where board members or commission members consider, conduct, or advise on public business. Public business can include the gathering of information, taking testimony, discuss, deliberate, recommend, vote. And as we said, these gatherings can occur by these various means. Let's talk about what a meeting isn't. A meeting isn't a chance or social gathering where no business is discussed. Now, clearly, if a public body, a board or commission, the voting members do end up representing a quorum in person, and they do discuss business, the public's business, then in fact, legally a meeting is occurring, and not having noticed that meeting, not having recorded that meeting, etc., could very well be a violation of the Open Meetings Act. So it's not about running into folks at the grocery store. It's not about, but where you do end up with a quorum, you do have to make sure that you're compliant with the Open Meetings Act. Meeting is not a press conference. That is not the conduct of the public business. That is a function of informing the public of things. It's not an email exchange between members of a public body unless the exchanges are a way of circumventing, i.e. the number of members that would represent a quorum or more are engaged in email exchanges, and that email exchange is meant to conduct public business away from the eyes and ears of the public in contravention of the OMA. It's not a committee or subcommittee meeting of the board or commission unless, again, the size of the committee or subcommittee comprise a quorum or more of the whole body, in which case even the meeting of the committee or subcommittee would still be subject to the same requirements of the Open Meetings Act. As I mentioned, unless established by legislation, the mayor's office, or regulations, a quorum is a simple majority, which is more than half. If there isn't a quorum, then the public body may be able to sit and discuss things, but they cannot conduct an official meeting or conduct official public business. Public bodies, as defined by the Act, is any government council, including the council, commission, or similar entity, including advisory bodies, mostly boards and commissions, that take official action by the voted members. Although there are certain excepted groups, such as the DC courts and area neighborhood commissions. Here with you all right at the top, local school advisory teams, etc., boards, commissions, boards of directors, advisory boards, and then the trustees of the public charter schools. District agencies, the mayor's cabinet, ANCs, the courts, and the professional staff away from a quorum. So for example, a gathering of DCPS employees who support LSATs, and where there are not a quorum of LSAT members, would not be a public body as defined by the OMA or this office. So the standard is openness, and meetings have to be open to the public unless the OMA permits closure. They have to allow for the public to have a physical presence, or the media at least to have a physical presence, and then also envisioned as televised access, a virtual presence. Now we're in a unique time frame legally in the post-pandemic period, and I'm going to discuss that here in a moment. This is a great graphic to just give you an idea. Public body meetings must be open to the public unless the OMA permits the closure. And here, a meeting is open if the public is permitted to be physically present, the news media is permitted to be physically present, or the meeting is televised. The way to let the public, the press, and others know, including our office, know is notice. We're going to talk about that here. So one of the key components of meetings is notice. First thing to notice is the time frame. As much notice as possible is required for a notice of a meeting, but notice must be given at least 48 hours or 2 business days before each meeting, whichever is greater, except for emergencies. And we'll talk about emergencies shortly. When a public body finds it necessary to call an emergency meeting to address an urgent matter, the notice, when it is provided, has to be provided to the public at the same time that the notice is provided to the members of the public body. We understand LSATs face some unique challenges. The requirement is notice be given at least 40 hours or 2 business days before each meeting. But, the issue here is effort and compliance, not a matter of, missing the requirement by an hour or 2 or a day here or there where it can't be avoided. What we're trying to do is help LSATs get compliant with the OMA, conduct their business in public, and effectively do the work that they do for the schools and for the community. In addition to the requirement for the posting of specific meetings, we do require by the statute that LSATs timely post not only their upcoming meetings, but at the beginning of the year, an annual schedule of their meetings. And that can be done either on the LSATs website, which I believe all LSATs now have websites individually. We also offer the ability, and I'll provide you the link further down, the LSAT the ability to post their annual schedule on the Office of Open Government Central Meetings Calendar, which is a central repository for meeting notice and for different bodies. Place is the next element after time. Notice has to be posted on the website of the public body or the district government, which would be, again, the central meeting calendar I mentioned, except that for emergency meetings, public bodies can either elect to use the internet posting method or post a physical paper notice in the office of the public body or a location. I believe that would be either the LSATs school itself or yes. So our understanding is, and I know in the case of a few that I've looked at, such for example as Maury Elementary, that there is at least a separate page for LSATs within a school's website. And I believe I've seen a standalone LSAT website, although I'm not remembering which school that was for. I can certainly check that. But even if it's the page, even if it's the LSAT page of a school's website, that is considered a sufficient place to post. Hopefully that answers your question. If not, please, feel free to speak up or share in the chat. Great. The notice, as I say, places, along with the draft agenda, the notice, which includes the elements we talked about, the date, the time, the place, and an agenda. And here is where I mentioned this at the very beginning. At open-dc.gov is where you'll find our central meeting calendar. Because most, I think 9 out of 10 members of LSATs are not generally district employees in terms of their function for the LSAT, they may be in their day jobs. There is a requirement that the LSAT obtain an email address that combines the name of the LSAT school and the acronym LSAT to conduct all official LSAT business. That's to prevent us not being able, as a government, to observe and access records that are conducting public business. So here's the example. It doesn't have to be school plus LSAT, first, last. That's what I've seen. So in this example, if there was a school called Best Elementary, it would be Best Elementary LSAT at whatever the email provider is. I've seen versions where it's the school LSAT chairperson, etc. As long as it's compliant and we know what that email address is, that is sufficient. We talked about it being, for emergency meetings can use either method and or the office. I think bodies, can't think of any. There are a few that don't have their own actual office. They're under the auspice of another agency. But generally speaking, there is almost always a physical presence, location where a meeting could be posted, meeting notice could be posted. But again, you can use the internet posting method. Unlike most other public bodies, LSATs don't have to publish in the DC Register because of the nature of the volunteer participation on the LSATs. But the annual calendar does have to be posted on that individual page that I mentioned or on our central meeting calendar at open-dc.gov. And you'll see our contact information at the end. The email credentials, it's not that you have to, so LSATs are unique in many ways. They create in many ways their own operating rules and bylaws or guidelines. As long as the chair or the administrative point of contact, which is what we normally have as far as somebody who can post to the central meeting calendar, as long as somebody on the LSAT has access to the, yes, you will receive these slides after. As long as somebody has access to the email, it's not required by us, that's out of our scope, whether all the members have access to the email, but that official business as far as the open meetings aspect is conducted through that email address. The LSAT itself would determine who has access and who does not to that email address. And that, as I say, is sort of beyond our scope in terms of oversight. I mentioned emergency meetings. When an emergency meeting has to happen, and this is not an unscheduled meeting, this is a meeting where there are very specific situations that occur that could involve public health, public safety, imminent threat, things like that. So it's a meeting that's not just out of the schedule or a non-scheduled meeting. It's an actual contingency. It's an actual unforeseen emergency where there simply is not time. When this happens, the chair or presiding officer of the LSAT has to open the meeting with a statement explaining the subject of the meeting, why the meeting's being held, the nature of the emergency, what it is that's causing an emergency meeting to need to be held, and has to tell how public notice was provided to the best of the body's ability. As I mentioned before, time, date, location, and at least the draft agenda for what's planned need to be provided when providing meeting notice. If a meeting intends or envisions having any portion of that meeting be in closure, which means not subject to public scrutiny by people outside of the quorum, outside of the voting members. That has to be noticed as well. And that notice also has to include a citation or a reference to the Open Meetings Act, which has very specific guidelines on why a portion of a meeting can be closed. And we'll get to that here. As I mentioned, we're in a unique period. The physical posting requirements for posting notices do not apply currently from March of 2020 at the beginning of the public health emergency. In theory, through the end of this year. Currently, the statute reads, I believe, till August, but we do expect that the DC Council is going to extend the exemption to the end of this year. They've signaled that that is their intention. So internet posting is sufficient at least until August, if not through the end of this calendar year. All meeting notices do have to include what's called the OOG statement at the end of all draft and final meeting agendas. So at the end of either a draft or meeting agenda, it needs to say, this meeting is governed by the Open Meetings Act. Please address any questions or complaints arising into this meeting to the Office of Open Government at opengovoffice@dc.gov. It just has to be legible, large enough to be read, and clear to anyone who's referencing any type of agenda that that statement is there. And that is a requirement of the Open Meetings Act. When you're doing closure, as I said, the official code does require citation to the justification of closure. Let's talk about the different justifications without getting into the deep legal aspect. A court order or a statute may require that certain matters be discussed in a closed session. Negotiations of various kinds could be occurring where the process would be chilled or made dysfunctional by being conducted in the open, where attorney-client privilege would exist or occur, where trade secrets are discussed, personnel matters, or matters involving a student's personally identifiable information. There could be evaluations by eligible chartering authorities, obviously education bodies in the case of LSATs, training for the LSAT members or for staff, collective bargaining negotiations in terms of labor and employment, anything having to do with the administration, preparation, or grading of exams or tests, certain deliberations, and then public safety and investigations. The citation can be found in the code. I'm going to go back here. So you would go to DC Official Code 2-575B, and then there you would have listed justifications, and you would cite in your explanation for closure what the reason was. This is just a reiteration. So in terms of closed, or what some folks call occasionally executive session, I don't prefer the term executive session, but it does get used. The protocol is as follows. You would open a regular public meeting and establish that there's a quorum present, and then you would vote and conduct your business for the open part of your meeting. Then the chair would move to enter into closed session, and then referencing, as I mentioned, the citation to the Open Meetings Act that justifies the closure, and then a vote would occur and the body would move into a closed session. Then during the closed session, the only public business that gets conducted would be a discussion of the matters that are referenced on the agenda that are part of the closed session: negotiations, training, deliberations. A record still needs to be made, and we'll discuss recording here in a moment, but a record still needs to be made of what is discussed in that closed session. Then, after leaving closed session, you would come back into the open public meeting, and then where and to the degree appropriate, you would report publicly any official action taken in closure and adjourn the open meeting. That is not to say that you disclose things that are protected by the justifications for disclosure. It's simply that you report what can and be appropriately reported back out to the maximum extent possible. This gives you just a little bit more step-by-step in terms of entering a closed session. Bear in mind, as I said, number 5, that recording is still obligatory. But then once you've gotten through the agenda items that justify the closure, you do come back to the public portion of the meeting. And then that meeting would be closed. And that is what takes you out. But there is no such thing as a fully closed meeting from start to finish that never has an open component. That's a misapprehension that a lot of people have. So there is a recording requirement. In general, all Open Meetings Act meetings, public body meetings, have to be recorded, either audio or video with audio recording of the meeting. Again, there's a general misapprehension that because there's language that is unclear to a lot of folks, that there is an alternative. It's not that there's an alternative. The expectation and requirement is that meetings are recorded by one of these two means. However, when not, and this is the legal word that gets folks tripped up, feasible, there are alternatives. Feasible in this case means there's an equipment breakdown. There is a reason that a recording can occur. At this point, most folks have cell phones that have a voice recorder app or have access to recording equipment, webcams, small digital recorders, things like that. So it does not get us clear of the requirements of the OMA to simply say, for example, the recording's not convenient, or that nobody, feels comfortable, for example, recording a meeting. That is still the requirement. However, in a non-feasible situation, meaning there's a problem or an unforeseen contingency, either a transcript is being prepared or detailed meeting minutes, which would then also need to be available. And we'll talk about the requirements for preserving records of meetings. Bear in mind, just a brief note on transcript, where there is a full transcript, which is a word-by-word documentary of the meeting. You do need to confer with whoever the provider of the transcription service is to make sure that there are no copyright violations that occur with the transcription. This again is that language, the not feasible. The minutes, at least the draft version, have to be publicly available no later than 3 business days after the meeting. And a notation has to be included at the top of any draft minutes that final minutes will be posted to the website on the next meeting date. Draft versus final, it seems a lot of people get sort of caught around the axle on this. Essentially, it's a very simple process to have the quorum, discuss, are there any corrections, amendments, things such to a draft set of minutes. And once that is established, that there's nothing further that needs to occur with the draft minutes, the chair of the meeting can simply move to have them adopted as final, and then they become final minutes. It's not intended to be a onerous or time-consuming process. It's simply a matter of making sure that the record is as complete and accurate as possible. A copy of the full record, including recording and transcript, shall be made available for public inspection as soon as possible, practical, but no later than 7 business days, not 7 calendar days, but 7 business days after the meeting. So the municipal regulations have a requirement, essentially, that the recordings, which include the notice, the minutes, the recording and the minutes, be maintained. And the DC code currently requires preservation of all meeting records for a minimum of 5 years. So if a meeting occurred in March of 2020, it would need to be maintained until March of 2025, at which point there would no longer be the requirement for that particular recording or set of minutes to be maintained. But it is a minimum of 5 years. That is not to say that you were expected to get rid of the recordings, but the requirement is a minimum of 5 years of preservation. As mentioned before, we're in that period where a public body can conduct meetings such as this via video or phone conference or other electronic means if there have been reasonable arrangements made to accommodate the public's right to attend. All meetings are being recorded. It's possible for all votes to be taken by roll call, which means that each individual member can signify their vote. And all provisions, as we've discussed up to this point, of the OMA do get adhered to. This, when provided, the copy of the slides can be scrutinized more deeply, but this essentially just is a very good synopsis of the contents of meeting minutes generally per, and I believe the 12th edition is the latest, of Robert's Rules of Order, which is a parliamentary procedure guide. It's not the only one. It's the most commonly used and referenced by public bodies, but it does give these detailed pieces about what constitutes good meeting minutes. Is very good. And as I say, they'll be in the slides as provided. This is from the municipal regulations. The minimum have to contain the date, the time, and the place, the names of the members that are either present or absent, which means you do need to account for everybody that is a member one way or the other. And then any motions and amendments, a record of all votes taken, and a general, at least, description of all matters considered during your meeting. So in and of itself, the OMA does not require a public comment period during a meeting. You can allow it, and your individual LSAT bylaws may require it or not require it or prohibit it. But you can have the ability to have a public comment period, and you can limit the amount of time that an individual speaks, or limit the amount of time total that's allowed for public comment, etc. That goes beyond both the OMA and our scope of oversight and compliance. So in and of itself, public comment is a matter for the public body itself, not for the OMA or this office. As I mentioned before, emergency meetings are not special meetings. Special meetings are meetings that are just not forecast by your annual meeting agenda, your regular meeting schedule. Special meetings, which just sent notice requirements the same, 48 hours or 2 business days at a minimum before your meeting. Emergency meetings are, true emergency or urgent situations where advance notice just isn't possible. And I mentioned the qualities or conditions of an emergency meeting before. At an emergency meeting, you have to give notice to the public at least at the same time you give it to the members of the LSATs. The presiding officer then has to open the meeting with the statement explaining the subject, clearly state the nature of the emergency, and witness how public notice was provided to the public. How public notice was provided. If there's going to be a cancellation of your meeting, then a meeting cancellation is a change in the annual schedule. Generally speaking, it requires as much notice as possible before the meeting occurs, but not less than 48 hours or 2 business days. Not always possible in an emergency or contingent situation, but the expectation is to the maximum extent possible that the cancellation requirement is complied with. And the notice, the notice of cancellation to the public has to state this following meeting at this date, at this time, at this place is canceled. It has to specifically use the word canceled. So there is a complaint process involved with open meetings and their conduct. So an aggrieved party, which is anybody who feels that there's a violation of the Open Meetings Act, including anonymous parties, can complain to this office for relief if a meeting may be or may have been, so maybe in the future, maybe in the past, be being conducted in violation of the Open Meetings Act. Except with, someone alleging that there's imminent prospective violation, a public body gets 30 days to respond to a complaint once it's filed with our office, with a possible extension of up to 5 additional business days. There's multiple ways for complaints to be submitted. They can be submitted in person at our office. They can be submitted online at open-dc.gov. They can be submitted by old-fashioned snail mail or by email. And the head of our office, the Director of Open Government, can seek multiple ways to try to resolve a complaint. They can try to bring the parties together and discuss and come to some conclusion. They can determine there's not a violation or prospective violation and dismiss. They can issue an advisory opinion, which we'll talk about here in a moment, or they can take any other step that's permitted by the code, the statute, or other Open Meetings Act regulations. Specifically in the past, and it was 2019 when LSATs became subject. It was determined for certain that LSATs were public bodies subject to the provisions of the Open Meetings Act. We've had several specific complaints about individual LSATs in their conduct of meetings. And so I want to just briefly mention what that looks like, because this is specific to LSATs. So in one case, there were documents that were distributed during a meeting and discussed by the public body. And then at the end, an individual wanted to retain a copy of the documentation or capture pictures of it. And they were coerced into not retaining that literature, and they complained. And it was determined that documents distributed during a meeting and discussed by a public body are part of the full record and must be posted along with the agenda and the detailed written record of the meeting. In another case, there was a failure to provide a link for the public to attend or view the monthly meeting, to timely provide notice of the meeting, and to provide recordings during the 2020 and 2021 school year. Those violations were identified, and the office issued an advisory opinion stating that they needed to comply and to provide those materials for every meeting in the future, and where possible to provide recordings for the meetings that occurred during that period. In the third instance, there was a failure to make a copy of the full record publicly available no later than 7 business days after the meeting, and to record the meeting by electronic means. And again, this office, OOG, found that the violations had occurred, and that going forward, the recordings would need to be made available no later than 7 business days, and that they would have to be recorded. Meetings themselves had to be recorded by electronic means. And that's why we offer these trainings, is because it's not a matter of always, a willful disregard for the rules. Sometimes it's simply a matter of not being aware of the rules. And we want to bring LSATs up to full understanding of, the requirements of openness in government and the conduct of its business. And we want to do everything we can to help LSATs be fully compliant. If and when we can't come to other result, as I mentioned, the OOG does have the option to bring a lawsuit in Superior Court for what's called injunctive relief, which means the ability of the court to direct a body or a person to not do something for any potential violations of the OMA, either before or after a meeting takes place. And there are numerous remedies that the court has besides the injunctive, the issuing of an injunction. They can require additional forms of notice by the public body to the public. They can postpone a meeting. They can issue a fine per violation of up to $250. Or for a meeting that's already occurred, they can declare that whatever action was voted upon and taken while in violation of the Open Meetings Act, that action or those actions are null and void. So let's do a quick summary here. Where the public body members represent a quorum, there can be a meeting where official business is conducted. Where there is not a quorum, the body can certainly start a gathering and attempt to determine if there's a quorum present, but they can't take formal action on public business. Notice requirement is 48 hours or 2 business days before a meeting. We know that right now, although the normal requirement is for physical posting and website notice, currently, as I said, internet notice is sufficient. Notice does have to include time, date, location, and draft agenda. And within that, if there is going to be any closed component, there has to be a citation to the Open Meetings Act for that closure. During the meeting, you have to record audio or video, the open and the closed sessions of the meeting. Obviously, they need to be recorded separately because the closed session needs to be available but not provided under a certain set of circumstances. Again, court requirement, FOIA requirement, etc. But the public record has to be made available to the public without any FOIA request required. The minutes, where minutes are being provided, the draft of those minutes has to be provided within 3 days, posted on the website. Again, that can also be posted on our central meetings calendar for where the meeting notice is. And then, detailed minutes can be provided as far out as the next date of meeting. As I mentioned, we look to each public body, including the LSATs, for there to be an administrative point of contact, just like we have with Freedom of Information officers at every agency. We look to our administrative points of contacts as the person who responds legally, not as a lawyer, but in terms of legal response to official requests, where we address our concerns or issues of specific OMA violations. When and if an APC or an administrative point of contact changes, please do be sure to report that person's new name and contact information, as well as the former person, just so we're sure, to us at OOG, and I'll be providing you our contact information here briefly. But we do want to keep track of who we can reach out to and interact with so that there aren't any misunderstandings or we don't get into any enforcement issues. You will reach out to us at the contact information I provide or via open-dc.gov for access to the central meeting calendar. There is a login that we create for those APCs, so they have access to post the annual schedule of meetings, meeting notices, cancellations, etc. We do also allow, by way of the OMA, the use of your own website for posting the records, but we do offer the CMC as an alternative. And that's where most people at this point who are at all sophisticated about openness go to, is they do, if they can't find the school or the LSAT website, they will look to the CMC. So this is our office. This is the individuals here who are with me today, as well as our leadership and support. So Nicole Allen is the Director of Open Government. Johnny I. Barton is our Chief Counsel. Sheree and Nick, who are here with me, well as myself, and then, as I say, our paralegal specialist, Kimberly Brown. You can either email the office generally, or you can email or contact us individually for assistance in questions about the OMA or FOIA, about the central meeting calendar, etc. And we're happy to respond to your requests as soon as possible and get you the answers and the assistance that you need. Does anyone have any questions who's here with us today? I can't see the chat, so if either of you see anything, please let me know.
Everyone's
Okay.
satisfied.
Yep. Great. Very good. Then we want to thank you all for joining us on a rainy Saturday and taking the time out of your busy schedules. Thanks for serving the community on your LSATs. And again, we look forward to assisting you in a way possible. If you do want to get copies of the slides, please feel free to put your email in the chat or email us at the office, and we'll be happy to get that material to you. And I see the clapping hands. Thank you very much. We appreciate it, and we look forward to seeing you all again very soon. Okay. Okay, Ms. McKnight, I have your email. And is there anybody else? Okay, it looks like that's all we're going to get for email. So have a great day, and we will talk to you all